time to hear from us today. This is a project that I've been involved in from the very beginning. Back in 2009, when I was a member of the neighborhood council in the area. I was a president of the East Hollywood Neighborhood Council. I was a member of the Hollywood Studio District Neighborhood Council, and the initial project was released with an MND. And we came here time and time again, and we said, look, an MND is not going to work. And the people that I represent in this community, not only as on the neighborhood council as their representative, but as an attorney, have only one thing that really gets them a seat at the table, and that's the law. And if the law is not being complied with, they have only one other option, which is litigation. In 2010, I was involved as an attorney of record in the initial lawsuit filed against the project relating to the MND. Target at that time withdrew its approvals. We went back to the drawing board. They did an EIR, and then the project was again approved, and I was again involved as attorney of record in the litigation, which, as you know, has resulted in the project being stalled in the place that it is. Of course, Target began construction on the project in the midst of this litigation that any first-year law student could have told you was highly likely to succeed. We came here time and time again, and we said, look, the exceptions to the specific plan are not supported by the law. There will be litigation. It will happen. And now we're saying the same thing. What's happening now is the city is proposing creating an entirely new sub-area within the specific plan, amending the specific plan that governs essentially the heart of Hollywood, amending the general plan as well, creating an entirely new sub-area, and saying that they can simply take a stapler and staple an addendum onto an existing EIR, and that that's going to be good enough. Well, it's not going to be good enough, and there will be litigation again over this issue, whether or not an addendum is sufficient. The standard is fairly easy to articulate. If you look at the case of Ventura Foothill Neighbors versus County of Ventura, that was a situation where they had issued an EIR for a project that was originally 75 feet tall. They increased the project to 90 feet. And they said, well, an addendum to the EIR, since everything's the same and it's just 15 feet higher, is going to be fine. And the court said, no, that's a major change to the project. Here we have an amendment to the specific plan creating an entirely new sub-area, okay, in the SNAP, okay? That is a new project for which a new EIR needs to be created. It will happen. The courts are going to look at this and they're going to say, yeah, you got to do an EIR. Now, of course, when the EIR ultimately comes out after this phase of the litigation prevails, there's going to be litigation again, right? Because we all know the EIR is going to be incomplete as well. And so that's the way it happens in Hollywood. That's just the way it is. It's planning through litigation. But at this point in time, right here, it's up to you guys. Are there going to be 2 lawsuits, or is there only going to be 1? Are we going to have a lawsuit about whether the addendum is proper, or are you just going to go back and do an EIR? Because if you just go back and do an EIR, we can skip to the second lawsuit right away and skip the first lawsuit altogether. I don't predict that's what's going to happen, because the history of this project has been one step in the same puddle over and over and over again. And, you know, for any bloggers or members of the press or whoever's here, when they write their articles pointing their fingers at alleged NIMBYs that are getting in the way of this project, when for 7 years I've been coming in front of these committees and saying, look, just do it right, people. Just do it right. We've been saying it over and over again. We don't have the luxury of allowing the law to be ignored in Hollywood, because the law is all we've got. That's the only tool we have to have a seat at the table. So just stop, think, ask somebody. If you know a friend who happens to be a land use attorney, call him up on your phone and ask him whether he thinks an addendum to an EIR is sufficient to support a completely new sub-area in the specific plan that governs Hollywood. It's not going to happen. Stop and think about it. At least try to set off on the right foot. I'm tired of all the litigation, frankly. I'm tired of it. I don't want to do it anymore. So, thank you.
Thank you.